Session here on Lagos Television. This morning, we'll be taking a look at a very pivotal topic, talking about the democracy and, of course, the judiciary. What is the link between both? And like we always say, the judiciary remains the last hope of the common man. But what is the link between the judiciary and the stability of democracy, especially in Nigeria as we speak today, where a lot of people are beginning to lose hope in the judiciary? But where is the connection, and where do we make that stand when it comes to the stability of democratic practice and the judiciary? We do have a guest in the studio this morning. He's a lawyer and political observer, and together we'll be taking a look at this topic. Bolanle Olugbani is our guest this morning. Thank you so much for being on the program today.
Thank you for having me.
Right, let's start this way. Let's probably start this way by taking your own definition of what democracy is. A lot of people have sat here and they've talked about the textbook definition of democracy and the kind of democracy Nigeria is practicing. But in your own terms, where do we marry both the textbook definition of democracy and what Nigeria is practicing?
Well, I think my own personal interpretation of democracy is leadership of the people with the consent of the people in the interest of the people.
Okay.
It's not enough for a leadership to, assume positions of authority, but they must reflect the wishes and aspirations of the people.
Right.
And they must have the consent of the people to remain valid, legitimate, and their ideas and policies must be progressive and welfareist. That, in essence, is democracy.
Okay.
If the feedback from the people is a no, don't do otherwise.
Okay.
Except you have overwhelming reasons to think or say that what you're about to do in the interest of the people is for their own overall interest. And at that point, you need to carry them along, to convince them, and to persuade them to support whatever policy that is you intend to execute in their own interests.
Okay. Jibala, sorry, let me just, ride on that. So if you look at how our leaders in Nigeria have been conforming with this, your interpretation of democracy, since Nigeria returned to democracy in 1999, would you say that indeed our leaders have conformed with this, your definition of democracy?
Substantially, I would say that it's been a 50-50. 50% for, 50% against my own idea and definition of democracy. By that I mean that our leaders have not imbibed the spirit of the Constitution, the ground norm, the document that says how we're to govern ourselves, how they are supposed to relate with the people, and how they are supposed to govern in the overall interest and welfare and security of the people. So that, having not imbibed the spirit of the Constitution, they are more in breach than in observance of the Constitution. And in doing so, they have looked at the Constitution as a document that can be amended or executed in such a manner as to suit their own interests mainly. And so there's a lot of impunity, cherry picking of judicial decisions, court rulings and judgments. It's only the ones that favor them or align with their interests that they seem to be able to implement. And when those decisions do not favor them, they are lethargic or perhaps extremely sluggish in implementing what the courts have interpreted as the proper position of the law and the provision of the Constitution.
Well, okay, I do know that constitutionally we have three arms of government: the executive arm, legislative, and the judiciary. Even though, from what you have narrated this morning, the politicians have chosen to look at that side of the law that favors them all the time, how complacent is the position of the judicial arm of government in all of this, in ensuring that our democracy thrives? You did mention earlier about court judgment, court rulings, and how the political class have decided to choose the ones that favor them. Shouldn't judiciary be checkmating them and, of course, putting them on track as to knowing that this is what the law says and this is what you should do?
Well, the 1999 Constitution and indeed the previous 1979 Constitution like the copy of the American system of presidential system of governance that Nigeria has, that has copied. And the essence of the Constitution is to have three co-equal branches of government: the executive, the legislature, and the judiciary. The executive implements, the legislature makes laws, and the judiciary interprets the law and resolves disputes, legal disputes between the state and the federal government, local government and state government, the individuals, the citizens of the country, and indeed any of the three branches of government, including their parastatals and agencies. So the role of the judiciary is such that the judiciary is saddled with the responsibility of upholding the law based on the proper interpretation and the intention of the legislature when they made the law. So you find that the executive, being an overbearing, quote and unquote, co-equal branch of government, because they have the resources, they've got the machinery, they've got the wherewithal, have sought to, in many occasions, undermine the effectiveness and the potency of the judiciary by their actions and their inactions. So you find out that except the judiciary is itself proactive in maintaining and defending its integrity, they are perhaps the weakest link in this co-equal branch of government setup that we have under the 1999 Constitution. The judiciary depends on the executive, which controls the Nigeria police, for implementation of rulings and judgments. The judiciary depends on the executive to implement orders and judgments made against parastatals, agencies, government officials, ministries, and all what, can make whatever decision they make, potent and effective. They still come back to the judiciary. The judiciary can influence the Inspector General of Police to be lethargic in implementing a court decision. They can seek to interpret a court decision in such a manner that is different from what the court intended. They can, decide that funds that are necessary for the smooth running of the administration of justice are not adequately or fully provided. These are all of the overbearing influences that those branches have over the judiciary, which may not be so for the legislature. The legislature, on the other hand, whether it's the National Assembly or the state assemblies, have the power of impeachment. Impeachment defined as, any infraction that appears to be that the chief executive of the state or the federal government has done that can lead to them bringing articles of impeachment and finding that person by their own legal provisions and the Constitution, guilty of such after a panel has been set up, and the person can be impeached by two-thirds. So with that sword of Damocles hanging over a chief executive of a state or the federal government, they tend to bow to the pressure of the legislature more than the respect that they have for the judiciary.
Absolutely.
The only time when the judiciary is feared mostly is when there's an election petition that can determine the
outcome.
The tenure of a governor or the president. And at that, that is when that is when the executive fears the judiciary the most.
Okay, so let me take it from this angle, just riding on Jibola's question and then your response. Having agreed to the facts that the executive sometimes can be overbearing in any way we tend to look at it, either knowingly or unknowingly, how then is the independence of the judiciary to every democratic stability, knowing full well that there should be three arms of government, there should be checks and balances, but then we understand that sometimes the executive can just, be domineering because, again, or because of, some of the things that you've mentioned. But if we intend to look at, the independence of the judiciary, how important really is that for a democratic stability?
Well, the independence of the judiciary must first start with those who are practicing the democracy.
So which means that the judiciary themselves must
understand their role,
right,
and defend their integrity and their freedom, robustly.
Okay.
But before that, all of the persons or personalities involved as officers elected or appointed in the co-equal branches of the executive, legislature, and judiciary must imbibe the spirit of the Constitution. It's not a winner take all. It's not one branch overbearing influence over the other. It is not about them. It is about the people of Nigeria. So they must first imbibe the spirit of the Constitution. Secondly, financial independence to the judiciary, where the judiciary does not rely on the executive for official houses, vehicles, their stipends, allowances, salaries, should not come through the executive arm in any way. It should flow from the federal account or the federation account to the central bank to something created, by the Constitution, like the National Judicial Council, who should be responsible and guard jealously that judicial independence. The execution of welfare and benefit to judges, the appointment of judges, the process for the appointment must have minimal political interference. The process must be so transparent that the best and those who are more or most experienced should be the ones that get to judicial office with the least possible influence from the political executive class. So a process must be designed that guards the type of human material that are elevated to the position of judicial officers. And I think that's the beginning.
Okay, we are where we are, according to what you have told us this morning about the judiciary not being financially independent of the executive. But as a stakeholder in this sector, the judiciary is the last hope of the common man. But it seems that because they are not financially independent, they are the lapdog of the executive, and they toss them around the way they like. So what do you think can be done to salvage the situation so that people will start looking up to the judiciary again with some level of respect?
Well, I think the first step is to ensure that the process by which judicial officers are appointed is immune, or the possibility of political interference is reduced to the barest minimum. Kudos must be given to the judiciary, starting from the Chief Justice of Nigeria to the heads of courts at the Court of Appeal, the High Courts, and the other courts of coordinate jurisdiction, the Federal High Court, National Industrial Court. I think that in a very difficult environment of deep political executive overbearance, they have done their best in the circumstances to maintain their independence, their integrity, and the fairness by which they rule and dispense justice. Kudos must be given to them. I'm a practitioner of the law. I've done that for over 30 years. And I understand the constraints. So to say that, they have not done their best would be quite unfair to them. In addition to that, I must say that the process of making the man on the street, believe that the judiciary has not been pocketed, the perception on the street that is usually bantered, that is usually bandied around, as if, a political office holder, who get judiciary, who is in control. That perception is what the judiciary itself, as a body, as a group, as an arm, co-equal arm of government, must make an effort to disabuse. Because while the reality is different, the average man on the street has the impression, somehow, I don't know how, that everything that comes out from the judiciary, is riddled with some form of political influence, manipulation, or some form of already state-managed outcome.
Okay, let me tell you how. Yes. What do you make of the situation? A poor man or a masses stole a 3310 phone, then is sentenced to 14 years.
Absolutely.
Then we have a politician who had stolen billions of naira. He will plea bargain, he will be bailed, and then you had someone who stole a tuber of yam, being sentenced to 14 years imprisonment. How does that put the trust of the people in the judiciary?
Very difficult for
Very
me to to be honest.
Very
These
difficult.
these are the
Realities,
conflicts and
right.
inconsistencies, that with all due respect and with all honesty, give rise to this perception.
Absolutely.
And it's quite unfortunate that, we have that type of impression being given, where the rich and the influential, the rich and the privileged seem to get a soft landing in the administration and the dispensation of justice. And that person who is, less financially or economically, well-to-do, gets the, rough end of the stick. It's unfortunate, but I think that it's an issue that the judiciary must address through workshops, symposia, even practice notes, and some kind of administrative curricula or training that helps them to level the playing field, and where plea bargaining, has a tendency to give, for instance, a perception that the person who is involved, or the accused or the defendant who is involved, is getting a soft landing. The law must be upheld. Plea bargaining must have rules, it must have standards, it must have limits. It must not be such that, nauseates one and totally befuddles the logic of, whatever it is we're doing in this system. I think another area is the fact that, and which the judiciary itself and lawyers must take responsibility for, is this area of conflicting court judgments and rulings from courts of coordinate jurisdiction. There, we have, every lawyer is trained that is the principle of stare decisis, judicial precedent. A lower court cannot give a judgment on an issue that is settled and has been decided, by the Supreme Court. Once the Supreme Court sets a standard, gives a judgment, similar facts, similar issues, a lower court, including the Court of Appeal,
cannot hear that case anymore.
No, they can hear the case, but the judgment must be in line with what has been established. You cannot deviate as a lower court from the reasoning of the Supreme Court in a matter that has progressed from the lowest to the highest court, and seek to set your own judicial precedent, infra dig, and create the impression that what the highest court in the land has done, is not important to you, or that there's no rule and that you can do something different. It's judicial rascality. So for courts of coordinate jurisdiction, maybe real-time online registration of courts and rulings for judges and judicial staff to check, to see whether such a matter with such parties, subject matter, is existing in other courts, whether a ruling has been given or a judgment has been given on that type of similar subject matter by another court of coordinate jurisdiction, will help to save the judiciary from some sort of, this type of legal embarrassments that seem to crop up and give the impression that one court is being manipulated by some people or political class, whilst another that gave a conflicting ruling or judgment is also being manipulated to counter that one. I know that's a problem in our society with the perception.
So somehow you have subtly also agreed that judiciary must also do a self-purging in this particular situation, because again, the judiciary must understand that there is a problem and must be willing to also tackle that problem. But let's also look at issues around election, because this is also very key to democracy and its stability. And so the question here is, we're beginning to make it a norm that the courts should also always be the decisive factor, or the one that would always decide when, of course, there are electioneering issues. Imagine INEC already in their budget saying that, we're budgeting a so amount for litigations. Should we always rely on the court to help us determine the outcome of elections? Or is this part of what the judiciary is also expected to look into? If we have credible elections that are decided by the people, and the people know that this were their own decisions, then we might not necessarily need to go to the court. So my question is, must we always get to the courts before election results are validated?
Well, the honest and fair answer is that on certain topics or issues, there's no avoiding the courts.
Okay.
On some, there should be a limit to litigation, and on some, we must find a way, just as has been provided for in the current Electoral Act, to avoid the courts from getting involved into day-to-day affairs and the workings and administration of political parties. The political parties must evolve and uphold a transparent system of administering their political parties without disputes that cannot be managed by them, which they push to the judiciary to help them to sort out. And because of the nature of the litigants who will be coming before the judiciary, ultimately the impression will be given that the judiciary is in favor of one group or the other within the political party. All of this, as has been upheld recently by the Supreme Court and provided for in the current Electoral Act, must be things that once the judges see that it has to do with the administration and internal workings and mechanisms of a political party, they should, as a matter of law, not get involved in such matters.
Okay.
For issues that border on the infringement of the fundamental rights of a member of a political party, that is, for instance, they're supposed to go to a primary, somebody's name is removed, thereby from the beginning he's not even allowed to participate
In the election.
in the primaries. After the primaries have been determined, somebody has won, the party decides that they are presenting another candidate. You know, these are issues fundamental to the rights of an individual is as a citizen of this country, for which they may approach a court of law to say that no, they didn't follow the constitution of the party, they didn't follow the provisions of the constitution of the country, and I want the courts to intervene as an exception to the rule in the Electoral Act to find out or to help me resolve why I was treated in such a manner, and for the court to make a definitive pronouncement or determination as to whether I ought to be senator, governor, or president, and was I rightly denied that opportunity or not by the political party.
Okay, you know, we have special kind of men and women playing politics in Nigeria. And so even when those things that are not judicially sane are pushed to the judiciary, when do we start having situations, or where can we start having situations whereby the judiciary will start rejecting such based on the merit of the law?
Like, give me an example.
Okay, like there is a political party now. Abimbola won the primary election of our political party, and our name was replaced with mine. And then you are the lawyer, and we approached you, knowing fully well that there is no merit in what we have brought before you. As the judicial officer, when would you have that confidence to start rejecting such, and the way that you tell your client that this is a no-go area for me, no matter what you're offering me?
Well, it has to do with professionalism, professional ethics, and indeed observance of the rule of law, with an avoidance of the practitioner to avoid an abuse of a court process. So it takes a lot of professionalism, ethical uprightness, and indeed the moral fiber, you know, because you see nowadays some of these errors in judgment are also punished by the courts. They punish legal practitioners from bringing matters that are
frivolous,
vexatious, frivolous, or an abuse of the court process, or what we know as forum shopping, with a view to either stultifying somebody's victory, denying them the fruits of their judgment or the fruits of their political victory. And as such, if a legal practitioner is found to be involved in any of that, there are sanctions imposed, you know, by the courts. But of course, from the face of claims before the judiciary in any matter, it can and the response from the other side, one can easily determine whether any of this has happened, whether it's frivolous, vexatious, an abuse of the court process, or whether They are seeking by that action to frustrate something that ought to be the fruit or benefit to the person who has freely, fairly, and rightly won, same. So all of us are involved. The practitioners, the judiciary, the litigants who, do what they want to do because they have the means, the wherewithal, and the resources. But it takes a lot for a practitioner to be able to say, no, this is not, you can try another lawyer, So, but you find that sometimes when one practitioner has the moral and, ethical
another person
fiber,
will take it.
yes, another person will take it. So,
Is it a matter of survival for such?
yes, there's of course the issue of professionalism, experience, and for some it may just be outright
Survival.
yes.
Okay.
Yes. There's no denying that fact.
Okay. Right. So let's look at, we know that accountability is also a key issue when it comes to democracy and stability. So what role does the judiciary play in ensuring that all other arms of government are accountable not only to the people but also to the system?
By upholding the law. It's as simple as that.
The rule of law, sometimes
Yes.
again, I know you've mentioned here that sometimes also the rule of law is also either not well interpreted or also changed by those that should actually uphold the rule of law. You gave an example earlier, perhaps you'd like to expatiate on this, where judgments from court of coordinated jurisdiction are given, or whether or not court orders are not obeyed or court rulings are not obeyed. We've had a couple of court orders that haven't been obeyed by the executive. And so in that stead, how should the judiciary play the ball when judgments that are handed down are not followed to the letter?
Unfortunately, the judiciary is not a trade union. It's not an association. Judicial officers ordinarily would not go on a strike. They will not, act like a trade union that says all matters involving the executive arm of government, we're not going to hear them.
Okay.
They cannot, as a matter of administrative policy or constitutional provision, take steps that are in direct conflict or confrontational to the executive arm or indeed any other arm of government. So the judiciary is in a very, very delicate position. It's in a very, very sensitive position. And it is usually the heads of the courts,
right,
including the Chief Justice of Nigeria, the National Judicial Council, that can make that representation to this selective cherry picking of what judgments and rulings to obey. The Federal Attorney General and Minister of Justice also has a role to play because he's the #1 law officer of the Federation, the #1 lawyer for the executive arm of government, who must also rightly advise the President and Commander-in-Chief as to what to do to restore or maintain confidence in the judiciary.
Okay.
It's not all about politics.
Right.
It's about stability in society, avoiding might is right, avoiding a breakdown of law and order, avoiding the perception that there's impunity. Ditto for the state commissioners for justice and the state attorneys general, the chief judges of the states, chief judges of courts. They must all, through administrative and strictly legal, interventions, influence the executive to follow or uphold or enforce, rulings and judgments, as made by the courts.
Mr. Olugbani, something that came to mind while you were trying to answer this question, and will be the fact that it's been almost 2 years since the Supreme Court gave a ruling on the financial autonomy for local government. Until date, it doesn't seem like that ruling has been totally adhered to. And if we're talking about democracy, the stability of democracy, as well as other arms of government, where does this position the judiciary? I know that you've explained that, yes, the judiciary will give a ruling. It now behoves on others to carry out the judgment. But Supreme Court is the final court in Nigeria, and it's been almost 2 years. We still have not had
full implementation.
Full implementation of that ruling. Where does this position the judiciary?
It's quite unfortunate. because there's no state governor. You know, even though the constitution allows the states to make laws for the administration of the local governments within their state. So there are inherent powers in the state houses of assembly. So while the National Assembly, the Senate and the House of Reps have passed a law for that autonomy, the president of the country has assented to it. Implementation becomes a problem because the various state governors, you know, a substantial number of them till date, have not purged themselves of the idea that the local government administration should be an appendage of the state, you know, government. In actual fact, there are 3 tiers of government in Nigeria: federal, state, and local government. What most people do not understand is that the local government chairman is like a governor in his local government.
Absolutely.
His supervisory councillors are his commissioners. His judiciary is the customary court or area court. His legislature is the council of councillors.
Right.
So they make bylaws for the local government. And as such, it's like the mayor of New York. He can be more influential, depending on the provisions of the law, than the governor of New York. The borough of or a county in England is the local government of that area, and the borough leader or chairman is the local government chairman. So I don't know whether it's a military hangover. I don't know whether it's just because you see all the state governors have sworn to uphold the provisions of the Constitution.
Absolutely.
In upholding the provisions of the Constitution, you are also duty bound to obey the rulings and judgments of the highest court in the land. So it is an impeachable offense for a state governor not to obey what he has sworn to uphold. And so that sanction or the decision, you know, as to whether, you know, they should be made to obey lies with their legislature, which is the House of Assembly, which must protect the interests of another tier of government, which is the local government in the state. It also lies with the president, who can direct his minister of finance to have accounts opened individually by every local government in Nigeria for money to be transferred to the 774 local governments in Nigeria directly without the consent of the governor of the state.
Okay. I know we have said so much about the judicial arm of government. By Friday this week, democracy would have been uninterrupted for 27 years. But leave judiciary out of it now. Let's look at the other arms of government, which is the executive and the legislative arm. How do you think they have fared in 27 years of uninterrupted democracy?
But one must not allow the prevailing mood to influence or affect one's assessment of the performance of the
other two arms.
The other 2 arms over the last 20-something years. But I think, to be fair, some have been at it for over 2 centuries. That's the system we copied from America. It's 230 or 200 and something years of these types of, you know, pitfalls, loopholes, problems, adjustments, imbibing the spirit, you know, falling, standing, running, you know. So where Nigeria is, you know, undergoing its own process. And each actor must know that they have a duty to enhance this our democratic experience and experiment. And as such, I wouldn't want to say that it has not been a good experience. I think that it has been a good experience. There's been a lot to cry and rejoice for. And I think that, to be fair, you know, I'm going to try and use a Yoruba, you know, saying that when there's an Oba whose reign is replete with, you know, peaceful progress, prosperity, there will be things said about him. In the converse, there's a ruler or leader who, in his own time, things are the opposite. It will also be said about him.
Right.
So for every councillor, local government chairman, governor, president, senate president, speaker of the house, all the political class, it will be said about you, you know, what exactly it is that you have done.
You've done, okay. Well, I would have to leave this conversation here this morning. Thank you so much, Bolanle Olugbani, lawyer and political observer, for finding time to be with us here on the conversation today. We appreciate your thoughts.
Thank you very much.
That's the much we take on this side of the table this morning. We'll take a quick break. The conversation returns shortly.
The views expressed on this program do not represent that of the producer, management of Lagos Television, or the Lagos State Government. They remain the perspectives of those expressing them. Thank you for staying with Lagos Television.